Welcome to Reducing Risk, a series of podcasts for medical protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medical legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. Today we're having the last in our series on privacy pitfalls, and once again we're lucky to have as our guest Stephanie Gregor from the Privacy Commission. Hi, Steph.
Hi, Lizzie.
And I also have with me again my colleagues, Dr. Sam King from MPS. Hi, Sam.
Hey, Lucy.
And Adam Holloway, one of the partners at MPS's panel law firm, Wood & Kearney. Hi, Adam.
Hello, Lucy.
Okay, so we have had 2 podcasts already going through a whole load of privacy questions that have turned up on our advice line. And this is our last one. And we've saved some particularly curly questions for last. So I hope you're ready, Steph. And the first one I thought would be a useful thing to discuss is about when family are involved in a patient's care. I think there's an awful lot nowadays where whānau-based care is really known to be good and effective for patients. But sometimes the requirements of the Health Information Privacy Code can make it hard for clinicians to involve the family in a patient's care. And this is particularly the case with mental health patients, where often the patient is in distress and at that time they don't want their family involved in their care. But the clinicians have got some doubt as to how they've come to that decision and their competency to make that decision. And they've also looked at the risk to the patient and others if that patient is released from hospital without the family having any understanding of what their care has been and what's involved in the discharge and what the risks are there. So when we're looking at trying to provide that whānau-based care, I'd just love to hear how we do that while not stepping outside the bounds of the Health Information Privacy Code, wanting to keep our patients safe, but also more than just the safety of it, actually providing the best care.
Yeah. Thanks, Lucy. It's a tricky one. Like you say, you've left the curly ones. But if it is an issue of true competency, then you've got the ways to actually sort of assess competency that, as clinicians, you'll know what to do. I don't know how you do that, but, so if it is a place where we come to the conclusion there is truly no competency, then it's sort of going down a different route, and then you kind of know how to deal with it.
No, I definitely agree. I think I'm talking more about on the edges of it, where the patient has got a mental health condition where they have got competency, but maybe their biases and their views have been affected.
Yeah, absolutely. So then if they do have competency, and then you're starting to look at Rule 11 of the Health Information Privacy Code about sharing the information with their family in that situation. There are a few exceptions to Rule 11 that might allow you to share information in those situations. Should I go through?
Yeah, that would be useful.
So I think a really key one in that will be the one in 11.2D2, which is the health and safety of the individual or another individual. So the way that Rule 11.2 of the HIPC works is that first you have to assess whether it's, I think the word is reasonable or practicable, to be able to seek authorization from that individual. So you may have asked them and they may have said no, in which case you can sort of go back again and then ask yourself that again. So they haven't given authorization, and even though I've tried, that's relevant to your decision making, but just because they've said no, that doesn't shut it off. So you might have tried it and you've said, well, I'm not able to, it's not practical to. But then you can go to the next bit, which is that if you think that sharing the information would lessen a serious threat to the health and safety of that individual or another individual. So if it is a true safety issue for that individual, as in if you think if you don't share this information with their family or whānau, that the risk that they're at of harm is significantly increased, and you know that sharing the information with the family, you reasonably believe that would lessen that risk, then even if they've said no, then you could share that information with the family if you're getting to that serious threat thing. And as with all privacy things, you need to really think it through, document your decision making. The key thing in that is, I think, to sort of get a handle on why you think the disclosure would lessen that threat, as in what are the specific ways that you think the family would help in those situations. And if at the point where you've got to that bit and you think, yep, we're at this, then you could share that with the family. There's another exception in Rule 11 that might sometimes be relevant, but it's not if the person has said don't share it. But there is one about sharing information with a family member in accordance with recognised professional practice if the person has made an express request for it not to be shared. So if they haven't actually said don't share this information, and just you kind of getting back into consent there. And so if they have said, no, don't share it with, you can't really rely on that particular one. So in that case, the key one that will come into play will be the serious threat one. But if it doesn't reach that level, if you just think, well, it actually probably would be good for them to have their family know what it is, but they may actually have a legitimate reason not to want to include their family. And if you think it would probably be helpful for them, it would probably be in their best interest for them to do it, but they say, no, don't share that information, then you can't, because you haven't got an exception that you can rely on. I mean, it's sort of tough, but people do have a right to make a decision that's not in their own best interests. But if you're getting to that sort of serious threat stage, then your clinical judgment sort of can override that. But if it's not at that point, then you can't.
That's interesting, though, that there is another provision for if it's usual practice.
Yeah.
And in which case, the next question would be, therefore, in those situations, are you better not to try and seek consent and get a no, and actually rely on the usual practice?
No, because...
No, you can't do that. Don't
you
bother.
can't do that because these all sit under Rule 11.2. And the sort of big headline in 11.2 is that the first thing you have to consider is that it is either not desirable or not practicable to obtain authorisation from the individual concerned. So the whole point of 11.2, which is part of the disclosure thing, is that the first thing you should do is, if not asking for them, at least fully turning your mind into why you think it's not appropriate to ask for authorisation. And I actually think I'm not a clinician, but I would be hard-pressed to find a situation where the best way to do it is to not try and seek consent.
Yes.
You may disagree. You're the clinician, not me. But
things are often a lot simpler if someone is under the Mental Health Act, because then, of course, you have an obligation to consult family and whānau under Section 7A. It is hard, and this is not helpful, but it's just an observation that I have of a tension between autonomy and heard Stephanie say, at the end of the day, patients are entitled to make decisions that are unwise for them, provided they've got capacity and they don't meet the threshold for being put under the Act. But then if something catastrophic goes wrong, often the system that kicks into gear to second guess and analyse and investigate what occurred takes a much more paternalistic look, where you'll be asked, but why didn't you consult the family? You should have convinced the patient to allow their spouse into the room, or should you have considered whether their refusal to allow you to involve family indicated something about their mental state, that the Act was in play, and you could have detained them for another period of assessment. There's all these questions get asked, particularly in the context of coroner's inquests, where people are searching for what could have gone differently here, and it's easy in that context to lose sight of the reality for doctors in the moment, where they're being asked by the law to be very respectful of people's autonomy and people's right to make sometimes poor decisions for themselves.
Yeah, and I think the problem in those, and that is exactly what I'm thinking about, where a young person has committed suicide, maybe in their early 20s, and the family are understandably distraught that they didn't know what was happening. And the problem is by then you've got serious harm. You know, by the time it's at the coroner. And so you look back and you say to the clinician, well, actually there was a risk of serious harm. You should have told the family. But making that determination of that risk of serious harm for every patient who has suicidal ideation is a really hard one to actually have your crystal ball to the future of which of those patients who say, please don't involve my family, and you making the decision that, oh no, I'm going to do that anyway because of this risk of serious harm that I think can be mitigated by talking to your family. That's a big decision when you don't know the future.
Yeah, because you're talking about therapeutic relationship. If you break it, the patient's gone anyway, you know, they're not going to come back to see you, they're not going to seek mental health care, and that puts the patient at increased risk. So I think, you know, we don't have a psychiatrist in the room today, but I think this is something that psychiatrists must think about an awful lot, because they've got to walk that line. And, you know, we often say to our members, you should discuss it with your senior colleagues, because sharing that problem and coming to a shared decision, making a shared decision, is actually far safer for the patients, but it's also far safer for the clinicians as well.
Yeah. And then documenting those discussions and documenting
them,
why you've got to where you are. And if you think it's a line call and you've decided to go, well, for, you know, to be safe, I'm going to put this at the serious harm end of the things because you think it could possibly go either way. Record the decisions for why you think it sits on that side of the line. And why, you know, it's prioritising patient safety there, isn't it? So
it's really hard, though, because I think that the privacy aspect isn't the only aspect you're often thinking about. And it often is the therapeutic relationship that you're really worried that actually you're increasing the risk of harm by telling their family, because all of a sudden they won't trust you either, you know? And so, yeah, it's just a really, really tricky situation. And I think the answer is, we're not always going to get it right, you know, but actually showing that you thought about it is probably a big step in the right direction to say, I've thought about whether or not it's appropriate for me to actually let the family know, even though the patient doesn't want me to do that.
Yeah, and like Sam said, discussing it with your clinical colleagues at that senior level as well can really help you both sort of just, you know, in your own heart be confident that you've made the right decision, as well as offering other perspectives into how to centre the patient in that decision.
Yeah, very good. That's very useful. Well, we're going to move on now to a completely different aspect of privacy and talking a little bit about general practice PMS systems. Now, for some of our listeners, they may not be GPs or know, but in New Zealand, there are a small handful of practice management systems that GPs use to record notes, write scripts, you know, get lab results, X-ray results, write referral letters. And more and more these days, we're getting privacy issues relating to those practice management systems. And I've had 2 calls recently, which I was very interested to hear Steph's opinion on, where patients have been very concerned about their online safety and very concerned that the practice PMS system has a cloud-based server. And so they've turned around to the practice and say, I don't want any of my health information to be on any electronic form. I don't want it in the servers. I don't want it in the cloud. I don't want it in your PMS system. I want to be looked after in a paper-based system. Whether or not that is a reasonable request of a patient to make.
I think that if you receive a request like that, maybe the first thing to do is actually try and interrogate with the patient what the basis for the concern is. If it is about the security safeguards, then maybe that's a good opportunity to be able to talk them through. Here are the security safeguards that are in place for those kind of things. Here are the access controls about who can actually access the information. Here are the situations in which we disclose, and here are all the situations in which we generally don't disclose the information. And then sort of also just tell them we don't run a paper-based system. There is not a way for us to actually be able to manage your information in a way other than that, if that's the case. And then it might get to the point where if they're really insistent, well, no, I will not have don't put my details into the computer, have a piece of paper that you have everything on and only deal with it that way. It might get to the point where actually you say, well, I've got no way to actually manage your health information then. So I'm not going to be able to continue to provide you with this clinical care if I'm not able to make the appropriate notes, if I'm not able to send the scripts in the way that I send the scripts. And it might get to the point where you have to disenroll that patient, but I'm not sure where the patient would go. Are there any agencies that are not doing these things electronically?
I don't know of any GPs that don't
No.
have a PMS. Everything's computerized.
Everything is.
Yeah.
I think some are cloud-based and some are still have got local servers, so that might be a difference. But I don't think anybody, I mean, really even getting lab results now, we don't get paper copies of labs. Everything comes electronically. It would be really hard to manage. And that was the advice we gave these practices, that if that's the patient's choice, you actually have to comply with their request to remove them from the system, but then you actually probably can't continue to provide care for them either.
Yeah. If you disenroll them or whatever it is, what does that mean for the information that's already there? Are you running into the health retention regulations in that situation? Or what do you actually do with the information you already have?
Yeah, there's the obligation to retain it in accordance with those regulations. But this isn't a case I was familiar with, but I completely agree with the advice. I think that in a modern environment where not only the collection, retention, and management of information like consult notes, but just your ability to communicate with other providers is entirely mediated and expected to be mediated and can only be mediated through a practice management system, then you would have to explain to the patient, there's no way for me to provide safe care to you and go through the medical counsel process for ending that therapeutic relationship.
Mm. And I think it's one of the things that there are some PMS systems, I believe, that it's really hard to actually delete a patient off. And I don't think the practices themselves can necessarily remove a patient completely. They can disenroll them and untick the box where they're going to be uploading for them. But actually to delete the patient off the system, I think can be actually very tricky, and I don't think it's necessarily something within the practice's power. So it probably would be something you'd have to go to the PMS system and ask them how to do it and what to do. I would have thought in that particular situation, if the patient is asking you to remove everything electronic, that would be a situation where I'd say, well, print off everything that you've got and you can sit on it for 10 years. But because you still have got the obligation to keep those notes in some form, and the patient is saying that paper is okay. So you could sit on their paper notes. Would you do that, Sam?
Yeah, I suppose you could pass the responsibility to the patient.
So print off the notes and give them to them? And
say that they've, this is their notes, and that you're passing the obligation to keep them securely for 10 years belongs to them. And the patient can obviously do with it what they will. But I can't see any other way around it. I mean, confidentialising does help, because if you confidentialise the whole file...
Can you confidentialise
Can you do that with the retention regulations? Like, if you can't get it back?
If you can't access it.
And if you can't connect it to the person that it's about?
No, you can access it, but if you confidentialise it, you specify who can access it. So no one else can see it but that doctor or, this particular person. So if needed, they can get into it.
Right, not anonymise it. Yeah, sorry, I've misunderstood there.
Yeah, no, so there's a reasonably common used part of the PMS system where you can click a button on a particular consult or a particular result, and that makes it confidential so that only one doctor can access that result.
Yeah.
It doesn't help us in the situation where patients are saying, I don't want that receptionist to have access to my notes, which is not that infrequent, that patients have a issue with certain people within the practice and they say, I only want my GP to be the only person who can access my notes. And from my understanding, is that right, Adam, that you can't do that?
I've only had the conversation in relation to one of the practice management systems, but it either wasn't possible or was very difficult to engage with them to get the whole file restricted to only one or a certain number of people. But I think if you had the request from a patient to provide care on the basis that only one GP, named GP, was able to access their health information, I would certainly be asking the question whether you can provide safe care to that person, because GPs do sometimes have holidays, and
Damn it, how unfair.
they do sometimes quite legitimately utilise other staff members for clinical tasks, because...
Or even just discussing the particular case with a colleague.
That's right.
Yeah.
If you think about the A&M situation where the clinician doesn't know the patient, they don't have old notes, it would be a similar situation to another GP in the practice not having access to that file, though, wouldn't it? So I'm wondering whether... I don't think it's reasonable. I don't think you can provide good care on that basis, but you could do it, if that makes sense. And I guess, does it come down to informed consent? So the patient is aware of the risks they take by saying that only this particular person can access my file.
I guess you're right, Sam, you could do it. It wouldn't be good care, but would it be enough of a concern to you as a practice that you would be able to navigate through the guidance for ending the therapeutic relationship?
Yeah, I guess that's the one thing
Can they
would
make
consider.
you do it? And I would have thought that in many situations you would be able to say, I'm very sorry, take your business elsewhere.
I think also a GP, I wouldn't know anything about the admin side of the general practice and, sending out charges and all the rest. There'd have to be other people available to actually run the background bit. I
think the difficulty with reception and having access, I was talking to a practice manager just recently about this, and she was saying that the reason why they have admin have access to clinical notes is because they need to make the ACC claims, they need to make the claims, and the only way they can do that is by accessing the file, which, for some patients is problematic. So I guess if the practice are unable to make it work from the financial perspective, then I guess the options they would have is say, look, I'm sorry, but we can't have you enrolled in our practice because it won't work, or we're just going to charge you differently. We can't make ACC claims, we can't make all these claims, and therefore this is what you will need to pay. I guess that's a possibility, but in practice that might not be workable.
Or potentially consistent with your back-to-back PHO agreement.
That's true. So I guess at the end of the day, it comes down to what the practices are prepared to do. If it's not practical, it's not going to work, and against policy, then I think it's reasonable, isn't it, to end the therapeutic relationship?
It's difficult though, isn't it? Because I've only started hearing these kind of concerns from patients in the last 2-3 years. It's a reasonably recent phenomenon that patients are really concerned about their data safety within a practice. And I do wonder, because if a patient isn't enrolled with you, every other practice in the country has got the same system. So it's not like there's a choice of another provider that doesn't have that system. I just wonder how those patients, if they have those concerns, how they can be accommodated, really, or maybe they can't be.
Tricky.
Tricky. There you go. That's that one. Talking about computers and the joy of computers, I think we might just talk a little bit about AI as well, and I'd be interested to hear what Steph thinks about some of the AI transcription tools that are being used at the moment. Their use is exploding in primary care at the moment, and we know that when you're introducing a new tool like that, important that you do your privacy impact assessment and go through the process to make sure that it's appropriate for you to use and that you're having the safeguards necessary so that you're still complying with your obligations under the Health Information Privacy Code. But one of the things that we are often asked, is there something else that we need? What are the privacy considerations with AI for practices, and what are their risks? And what are the other things to think about in that context?
Yeah. I'll start by talking about the sort of transcription stuff. I think I've got further thoughts about the use in diagnosis and things like this, but I'll just start with the sort of the common current use case, which is you got the AI tool sitting there on the console, sort of summarizing the conversation, putting those sort of into your patient
and you cut
file.
And paste it into the file.
Obviously, informed consent is really key with these kind of things. I think that depending on the reason that someone is coming to see a doctor, actually their sort of tolerance for whether they're happy for AI to quote unquote be involved might change. One way that I think it could be done is, so if you're proposing to use an AI system in these consults, the first time that you're doing that with a patient, actually be prepared to have a bit of a conversation with them, seek their informed consent. You're used to seeking consent on all sorts of things, and so this is sort of no different to that. Be ready to answer questions. And these are all questions that you should know the answer to if you've done an appropriate PIA before you're putting the system in place, which is, where is the information stored? How do you make sure that the information is accurate? Who will this information be disclosed to? Will this AI somehow be making or influencing clinical decisions? Those kind of things. And it might be that as a practice or based on a system, you might have a sort of fact sheet about how this AI works to actually help the person understand that. And if they say, no, I don't want you to use AI, I think you should just respect that and just go back to the sort of traditional way of recording the notes. I know that some clinics will continue to ask for consent in all future consults, and I actually think that is a really good idea. I think you don't have to have that full, really intense discussion each time. But I do think that people come to see a clinician for different reasons every time. And it may be that this one time I've got something that I don't care if AI sort of sucks up. But this other time is actually really sensitive. And whether it's, a true risk of my information being disclosed, or if it's something that I perceive, I don't want AI to be listening to what I'm saying. And so someone comes into your clinic and you're, oh, hello, how's the weather out there? Did we talk about AI last time? Are you still okay for me to use that today? Yes, no, and then, sort of be on your way and those kind of things. So there's all that informed consent stuff about when you're talking to the patient themselves. We'll get to diagnosis later, won't we? But I think that a key thing with AI is that it really does make quite sweeping statements with real confidence that turn out to be wrong, and it can listen to things wrong. It can, if it's making a summary of what the patient's saying, it could come up with a different sort of slant on it than what you might have done if you were typing. And the key thing I'd say is that even if you're using AI to do some of the things, all of your requirements that sit in the HIPC about accuracy, obviously about security, about the reasons that you're using things and those kind of things, they still all apply, even if AI is the one that, that's listening to the conversation. So you are ultimately still responsible for making sure it's all right.
Yeah, I think I use a transcribing service, and I've done a few talks around the place on this, and probably my biggest concern is that doctors are not consenting patients appropriately for it.
Yeah.
You can't just say, are you okay if I use a transcribing tool? That doesn't
what does that mean?
Yeah, or even just to say an AI transcribing tool, because it doesn't confer to the patient. And I've actually had quite a few patients who will say, oh, no thanks. And which is obviously fine, and I just have to do it the old-fashioned way. But I think knowing that quite a few patients are sensitive about that, it's important that we do consent patients. Great. Because if there is an issue down the track and the patient will say, actually, no, the doctor didn't explain to me what that really meant. I didn't know that my information was going overseas. if I'd known that, etc., etc. And I think that clinicians put themselves at risk. And I think too that the whole checking of the clinical note before you file it is so important, because you're right, it makes stuff up and gets a lot of things wrong. So I think it's a very important step.
I often wonder when it's going to be so normal that the consent will be implicit in, when people sign up to enrol, it's in the privacy statement and everything.
Becomes an opt-off system.
And the rapidity with which it's taking over makes me think that very soon it is just going to be ubiquitous and expected and normal practice. And, yes, we all talked about it at the first couple of years, but now no one's talking about it anymore because we just all do it,
Yeah, but authorization and all of the stuff that you need to let someone know about Rule 3 is not based on how normal something is. It's based on what you're doing with the information that you're collecting from that individual in these circumstances. So maybe it will get sort of subsumed eventually into these Rule 3 things, but I do think that the consent is still really, really key.
I suspect you're right that it's going to become so every day that on the enrolment form it'll be we use AI transcribing,
on your privacy statement,
and you can opt off.
Yeah,
so it'll be an opt-off system rather than opt-on.
Yeah, so every when you enrol, every time you get a privacy statement from your GP about what we do with your health information and how we use it and whatever else. So I assume the AI stuff's all going to be on that, and people are going to sign it at the time that they enrol, and every 3 years with the re-enrollment process. And it will just become normal.
I certainly haven't been keeping up on what sort of range of AI transcribing tools are available or whether they're domestic or international. But I certainly agree with Stephanie. It's really important to understand the tool you've chosen to use. And I think hopefully one of the things that may happen in the future is that the market gets a bit more sophisticated or about what's being offered in the New Zealand marketplace and its consistency with our privacy obligations. So if you were to start using an overseas-based tool where whatever is heard, that data is transmitted out of New Zealand and beyond our control, and potentially under a contractual arrangement which doesn't include or respect our privacy protections, then you're immediately in breach, arguably, of the Health Information Privacy Code from the get-go. It's a complicated and sophisticated set of judgment calls, and you could certainly see an obvious place and resource-constrained environment for things like AI transcription, but hopefully some of the big PMS providers like
they already are integrated.
And they're both integrating these tools, but then making them very domestic in the sense that
they're not. The integration though is that you can click on the link and it will take you to the external site. So they're not really integrated. They're more just an easy access tool. There are some being developed within New Zealand. I don't know whether they'll become widespread within New Zealand or not, because I don't know the quality of them as yet. But it's fast moving, and I think.
See, I'm not sure, but I think the main one that's out there is actually currently the servers are in Sydney, but they're planning to be in New Zealand. Is that right? That's what
I haven't heard that
that's
they're moving
what I
to
understood.
New Zealand.
Yeah.
Currently, the one I use, which I think is the most popular, is in Australia.
It's about where the servers are, but also about how the AI agency is actually treating your information and the information you put. If it, you don't do it in ChatGPT, but if you're putting information into ChatGPT, really, that is a disclosure, because it is then used as training data worldwide for lots of other things. If you have this sort of, walled garden where actually you still have full control of the information and it's only training on other information that you've put in it, then that's one thing. But actually, if you're sharing the information with the AI provider, there might be some situations where it falls sort of within Section 11 of the Privacy Act, which is where they're acting as a processor for you, and it's not a disclosure, and then the fact that it's in Sydney is less of an issue. But if what you're actually doing is disclosing it because they're going to use it for their own purposes, which if they're using it for training data, already quite possibly doing, then actually you're starting to engage a lot more things in the HIPC, including potentially Rule 12, which is about international information sharing. So a really key thing
I
is
think they are
do the
really
PIA.
careful. Yeah, they are. You've got to do your PIA, and I think the common one that's used, the data that's transmitted offshore is already anonymized, and that it isn't used for a large language model. So, and yeah, you're right though. You've got to do your privacy impact assessment, your PIA, and go from there and actually know what you're consenting the patients for. Because if you don't know, how are the patients going to know?
And we have some guidance on our website that we put out, a couple of years ago now in 2023, but about how to think about how AI interacts with, it's about the Privacy Act more generally, but you can apply a lot of that to the HIPC about actually where the questions that you need to ask yourselves, what they are, to make sure that you know what's happening with the information.
We
so
did
you can make an informed decision.
we did a webinar a couple of years ago with a lawyer from Watton County, Joe Fitzgerald. So if any of our members want to access that, it's on our website on Prism.
The other thing is the PIAs have been done by some of the PHOs for the commoner transcription systems. So it's actually really, and you can just access them and actually see, and it's kind of been done for you, and they've got all that information, which is useful. So I think for a lot of clinicians, they're using the ones that have already been
which is useful, but as long as they are actually engaging with those PIAs, not just saying, oh yeah, there's a PIA done, yeah, I'm satisfied, because
you've actually got to read it.
It's still you that has to be satisfied.
Fair enough.
If you disagree with it, use it differently.
Yeah, absolutely. Fair enough. Just moving on then to those large language models and thinking about ChatGPT, because that is a kind of it is getting to be ubiquitous again. I think at the moment, Te Whatu Ora aren't allowing the use of it, but I think they may not be allowing it, but I think a lot of young hospital doctors are using it. And, obviously the issue there is that information is released and used, but also the accuracy of what comes back. So I don't know, have you got any thoughts about the diagnostic models and the ones that give you an idea of differential diagnoses rather than just transcription?
Yeah. Approach with caution, I think, is my sort of overarching thing there. I am really concerned if AI is making decisions without a human in the loop, if they are giving information in order to help you make a clinical decision and you're not actually putting personal information in, health information, and then maybe that's one thing. But at the end of the day, the clinical responsibility of the clinician sits with the clinician. And so if the AI has had an accuracy issue, either with accuracy of what actually the presenting issues are or what they could mean, or if there is actually a really common explanation for those kind of things, which the AI hasn't even brought up, but a clinician really should know, then the fact that you did it with AI is not going to remove your clinical responsibility on those kind of things. And so sort of understanding how the AI is saying the things that it's saying to you and then being able to interrogate it and disregard it as appropriate, I think is going to be really key for the sort of professional safety of clinicians.
Yeah, I think that we will have to learn how to use it as an adjunct, as a tool, not as a replacement. And I think it will become, the temptation will be that we'll use it to replace our brains.
Yeah.
When actually it should just be a tool. And again, I think consent is really important. I don't think we should be inputting patient data, even if it hasn't got a name and a date of birth on it, without the patient being made aware that this is what you're doing.
Yeah, I agree. And just being really aware. I mean, I'm not a doctor, but I am a lawyer, and the Law Society put out this guidance on AI recently, and it's talking about some court cases where in the filings there have been these cases that have been, put in that don't exist. It's not even that they don't say that they've got the wrong thing that it's saying. It's just that the LLM has just completely made up a case. And if that's happening in that side, I would be really surprised if there's not a new disease that is being made up.
And the thing is, if you don't check, you don't know.
Exactly. And so you should always check. And if you think, I wonder where this is coming from, then that is a really good sign to fully interrogate that and make sure you agree. And if not, change it.
I went to a workshop on AI recently, and the person who was leading this got us half the room to use one AI tool, which was ChatGPT, and the other one was, I can't even remember the name of, and we put the same questions in and got completely different answers. It was really quite scary, to be honest, and a bit of an eye-opener for most of us in the room. And I think that it just serves as a warning that we don't know what we don't know often.
No, and an AI hasn't gone to medical school. An AI doesn't actually have a brain. An AI is just used to recognising patterns and putting those things in. But wasn't it what you say, that medicine's as much of an art as a science?
Yes.
Often, you actually have to be able to exercise your clinical judgment based on your experience.
Yeah. And it's one of the things that when I was thinking about privacy impact statements and thinking about consenting our patients for, what's happening with your health data, I was talking to one of my colleagues about the fact that, we all have our cell phones with us in consult rooms, and we all merrily click and accept Apple's terms and conditions or your phone's terms and conditions without really reading them. And we all know that our cell phones listen to our consultations, and they listen to everything that we do all day, and they target us with ads. I don't know what the Privacy Commission has to say about that, but I kind of think, should we actually be telling all our patients, if you're worried about AI, you better turn your cell phone off because it's listening too. And what's happening with that data, goodness knows. That's probably...
Well,
I'm sounding like a conspiracy theorist, I know it, but
I mean, coming from an HRPC perspective and a privacy perspective, let the patient worry about their own relationship with their iPhone. I think is the key thing there. How they're using their own personal technology is up to them. The whole sort of crux of the HIPC and the Privacy Act is it is related to the relationship between the agency and the individual. So, you and your patient, not the patient and Apple. That's something for the patient to take up with Apple. Right. As you've got enough to worry about, I think, is probably my thing without that.
Fair enough. It's just one of the thoughts that I kind of think everyone gets worried about AI, and then I think, but actually it's so much part already of everything that we do, and that surveillance is already there. Anyway, there you go. That's my thoughts on that one. So look, just before we finish, because we have got to finish and it's been so interesting, but I wondered if you had any thoughts for us on recent trends in privacy breaches or things that you think would be useful for us to know that you working at the Privacy Commissioner's Office actually could help us kind of understand what the environment's looking like now, what your concerns are.
So we do track, obviously, notifiable privacy breaches. And so a breach under the Act is notified to us if it causes or has the potential to cause serious harm. So we're talking at that serious harm level, these trends. People, when they think privacy breach, they think hack. They think my information's been exfiltrated. And that definitely happens, and those are on the rise, and particularly attempts are on the rise for malicious actors. So make sure that you meet your IPv5 requirements, which is your storage and security requirements. Use multi-factor authentication to really minimise the chances of that happening. But what we're still seeing year after year is human error. Keeps coming back as a key cause of notifiable privacy breaches. Employee browsing, which we've talked about in previous podcasts, that's a real key one that comes. People accessing information they've got no real purpose to do, and then that causing harm to an individual. And disclosure without justification. And so those kind of things can be as simple as sending an email to someone who has a similar name to someone else with their clinical notes. If you're doing this over email in the first place, then maybe that's another thing to be thinking about. But sending it to the wrong person, and then that becomes a privacy breach. So, worry about the big stuff when it comes to hacks and things like that. But also just make sure you've got your systems set up and your processes set up and your staff training set up so that they know what to do and what not to do with personal information or with health information that they're handling. Yeah.
Someone I know, this was a few years ago when, in the days when we used to send recalls by letter, and in the envelope window, it had obviously the person's name, and then you could see that it was your cervical smear is due. because the letter had shifted in the
shifted
envelope.
up. Oh.
And I just thought something as simple as sending a letter, to my thinking, was actually a significant privacy breach.
Yeah, and privacy risk is not new. Privacy risk has not just come up because electronic exists. It just has a sort of different flavour to how you've got to look at it and how you've got to think about mitigating it. Yeah.
I think sending the email to the wrong person has got to be one that I've done it. I think most of us
So
at some
easy
point
to do.
have
And
actually.
if it happens, then there are often ways that you can deal with it. It's just the fringe cases that is actually a huge issue. I mean, if you're sending information to an estranged partner when there is a violence issue or things like that, that is a huge harm issue. If you've accidentally sent it to one of your other colleagues, you've sent it to the wrong Sam, I don't know, then there are ways that you can manage that you can mitigate it. And one thing when assessing serious harm breaches that our compliance team takes into account is what are the actions that have been taken to sort of mitigate the harm. And actually, if you ask, hey, that wasn't meant for you, can you delete it? And you confirm you delete it and not access it, and then they respond saying, yep, done, thanks, that will actually probably really go a long way to mitigating any harm that could arise from those things. So not all privacy breaches are created equal.
And there is information on your website, isn't there, around what to do if you have a privacy breach, which I think is very helpful.
Yeah, we have heaps of information on our website, yes, about how to handle a privacy breach, about how to handle a complaint. So if there's a complaint from an individual, then we have some really good information about how you can do that. If you can handle that actually with the individual themselves, that is way easier than having it escalated to our office. And actually often, you've been, over the last few podcasts, we've been talking about the importance of maintaining that therapeutic relationship. Actually maintaining the goodwill within those complaints is a really positive way to keep that relationship strong. We have heaps of guidance on our website. There's modules, we've got webinars. Have a look, privacy.org.nz, or send me an email, guidance@privacy.org.nz if you ever want to chat about privacy.
And notify us.
Notify us.
So
yeah.
I don't know if everyone out there knows, but if you have had a privacy breach, that's kind of the first thing to do, is to go through the process and actually see, have you got an obligation to notify the Privacy Commissioner about it?
Absolutely. And if you've done it through Notify Us, then you can actually also let us know through that tool, which is really good. And you have to do it as soon as reasonably practicable is the requirement, but we normally say about 72 hours, within about 72 hours of becoming aware of a breach. But the Notify Us tool can actually help you figure out if it is even notifiable in the first place.
Yeah, and that's really useful. And I think I always direct members towards, do the tool first. let's do the tool first and see what's happening, see whether we need to notify it. So that's useful. I don't know, Adam, if you've got anything you wanted to add at the end of our chat about privacy.
No, I mean, I agree with Stephanie that the majority of cases probably have a simple solution. And like most things in life, having a chat about it, explaining what's happened, seeking a resolution will work. Sadly, the ones that we tend to deal with are where that hasn't worked, and it can be immensely frustrating and difficult, and prolonged. You're more likely to avoid that sort of outcome if you've handled it well at the beginning. And there is really good advice on the Privacy Commission's website, or utilise the tool of calling MPS and be guided towards the right things, or if necessary be guided towards one of the MPS people who can assist you, because getting it right, meeting the Act's timeframes, those sorts of things are important, and you can be helped to do that.
My final comment would be, privacy is very difficult. It's very tricky. Every situation turns on its own facts, and it's far better to call MPS early in the piece than to struggle on and then perhaps create a situation that could have been resolved earlier.
Yeah. And when in doubt, don't release. I think
you've always got time to
ask
release
first and then release. Don't release and then think, I wonder if I should have done that. Okay. So thank you to our listeners for listening to this podcast. I hope that it's been helpful. And thank you very much to Stephanie for joining us for these last 3 podcasts. It's
my
been
pleasure.
great
Thanks
to
for
have
having
your
me.
expertise with us. As Sam said, if you've got any specific questions, call us on our advice line. And if you like medical protection podcasts, please do subscribe and leave us a review. And if you'd like a podcast on a specific topic, please email nzpodcasts@medicalprotection.org. So all that's left now is to say thank you to everyone for coming, and have a good day.
Thanks, Lucy.
Thanks, Lucy.
Thanks for having us.